So hello everyone, I am Amish Parmate and today we are going to study the topic of right of unpaid seller. So this topic is provided under the Act Sale of Goods. So before going into this topic, we should understand the title of this act, that is Sale of Goods. So section 4 of this act deals with contract of sale. So in this contract of sale, if you get to understand the definition of contract of sale, then it is very easy for you to understand what is sale and what is agreement to sale. So basically there are four essential elements in this definition of contract of sale. Number one are parties who are seller and buyer. Number two, they transfer or agrees to transfer Number three, the property in the goods is transferred or agrees to transfer. And fourth is price. So with these four essential elements, we can make the definition of contract of sale. So basically, contract of sale is a contract whereby seller transfers or agrees to transfer property in the goods to buyer for the price. Now, if you understand this definition of contract of sale, so it's very easy to get the definition of sale from these essential elements. So for the definition of sale, we need to remove this. So now sale means, in a contract of sale, when seller transfers property in the goods to buyer for price, then it is sale. Okay, and in contract of sale, when seller agrees to transfer property in the goods for price to the buyer, then it is agreement to sale. So now we can say that in sale we transfer the property in the goods, and in agreement to sell, the seller agrees to transfer the property in the goods. Okay, so this is sale and agreement to sale. Now coming on to the definition of goods, because the title of the act is Sale of Goods Act. We understand what is sale, now we are going to understand what is goods. So this goods may be existing goods or future goods. Okay, section 2 clause 7 of Sale of Goods Act define the term goods. So good means every kind of movable property, every kind of, highlight this word, movable property. Okay, except, good means every kind of movable property except number one, actionable claim, and number two, money. But these goods also includes share, debentures, stocks, and things attached to earth which is going to be severed. Okay, so this is the definition of goods, but this is the definition of existing goods. But goods also includes under it future goods. So section 2 clause 6 define this future goods. So these future goods are those goods which are going to be, number one, acquired, number two, manufactured, number three, produced by the seller after contract of sale. Okay, so this is the whole definition, or we can say the meaning of the act Sale of Goods. Now we will go on to our main topic, which is right of unpaid seller, or we can say unpaid seller's right. Okay, so before understanding the rights of the unpaid seller, we should know who is the unpaid seller. So section 45 of Sale of Goods Act define the term who is unpaid seller. So the seller is deemed to be an unpaid seller when number one, whole of the price is not being paid or tendered to him. Number one, remember, when whole price is not paid or tendered, and number two, when negotiable instrument is received to the seller and such negotiable instrument is dishonored. So unpaid seller is the one to whom the whole price is not being paid or tendered, and number two, to whom the negotiable instrument is received and such negotiable instrument is dishonored. Okay, negotiable instrument dishonored. So this is the definition of unpaid seller. Now coming on to the rights of unpaid seller. So these rights of unpaid seller can be categorized under two subheads. Number one, it is right of unpaid seller against goods, and number two, the right of unpaid seller against the buyer. Okay, this is given under section 46 to 54, and this is given under section 55 and 56 of Sale of Goods Act. So section 46 gives three rights of unpaid seller. Number one, right against lien. Number two, right to stoppage in transit, and number three, resale. Now we should understand what is lien. Now let's say this is a duster. Okay, so lien means retaining something. So I am exercising the lien on this duster, means I am retaining this duster. So we should understand, for the purpose of lien, the possession of the goods should be should have with the person. Without possession, you cannot exercise lien. So this is a basic understanding of lien. So when the unpaid seller exercises his right to lien, which is given under section 47 of the Sale of Goods Act, so it states that when the seller is in possession of the goods, then he can retain the possession of the goods if the three conditions, or if following three conditions are satisfied. Number one, if the goods are being sold on the credit and the term of the credit expires. Number one. Number two, the goods had not been given on the credit, and number three, if the buyer becomes insolvent. In these three specific conditions, the seller can exercise the right to lien over the goods. Now this unpaid seller right of lien can also be exercised over the part of the goods. Let's say if part of the goods has been delivered to the buyer and there are certain remaining goods, then on the remaining goods the seller has a right to exercise the right to lien. Now coming on to the termination of lien, which is given under 49 of Sale of Goods Act. Okay, so 47 talks about right to lien, 48 talks about part, the right to lien exercising over the part, and 49 talks about termination. So this right to lien can be terminated when number one, as I have told you, lien can be exercised when the seller has the possession of the goods. So when he parted with the possession, then simply we can say that he cannot exercise the lien. So number one, when he parted with the possession. Number two, when such possession has been acquired by the buyer, then the lien is terminated. And number three, when the seller himself waive the right of lien. Okay, so this is the first right of unpaid seller, which is right to lien. Now coming on to the second right, which is right to stoppage in transit. Okay, so this right to stoppage in transit is given under section 50 of the Sale of Goods Act, and it says that when the seller is parted with the possession of the goods and those goods are in the transmission and such goods are being given to the wharfinger or carrier or bailey, then in those situations the seller can exercise this right to stoppage in transit if he knows, or if it comes to his knowledge, that the buyer has become insolvent. So this stoppage in transit can be exercised only when only when the buyer becomes insolvent. Okay. And now section 51 of this Sale of Goods Act talks about duration of transit. So duration of transit will be when the seller is parted with the possession, that is to say he has delivered the goods to the carrier or belly and the buyer has not yet obtained the possession. So this duration, seller parted with the possession and buyer not acquired the possession, this time period, in this time period the seller can exercise right to stoppage in transit. And then this right to stoppage in transit can be effected by taking actual possession of the goods or by giving notice to the carrier or to the bailey, and after giving notice this carrier or bailey will return the goods to the seller. Okay, and this now we should also understand when this right to stoppage in transit can be terminated. So from the basic prudence understanding we can say that this right to stoppage in transit can be terminated when the buyer has obtained the possession, because now the goods are not in the transit, therefore this right cannot be exercised. Number 2, when the goods has reached the appointed destination. Okay, even if the buyer has not yet obtained the possession, but the time or the moment when the goods reached the appointed destination, we could say that the transit has come to an end. Or number 3, when the buyer acknowledges the delivery to the seller, then the stoppage in transit comes to an end. Okay, so these were the 2 rights of unpaid seller. Now coming on to the last right of unpaid seller, which is right to resale, which is given under section 54 of Sale of Goods Act. So this right to resale can be exercised after giving notice to the buyer to pay the price, and even after the notice, if the buyer fails to pay the price, then the seller can exercise his right to resale. Now let's say if the seller fails to give the notice to the buyer and he resales the good, then what will be the consequences? So there are 2 basic consequences of it. Number 1, if seller resales the good without giving notice to the buyer, then he cannot sue the buyer for breach of contract. And number 2, the buyer can claim the profit. Okay, so if the notice is not given, then the seller cannot sue buyer, and secondly buyer can also claim the profit of the resale of the goods. So these are the 3 right of the unpaid seller against the goods. Now coming on to the right of unpaid seller against the buyer. Now this right of unpaid seller against the buyer is given under section 55 and 56 of Sale of Goods Act. So section 55 of Sale of Goods Act states that suit for price. This is section 55. Okay, let's say if the seller gives the good to the buyer or delivers the good to the buyer and the buyer is not tendering or paying the price, then in those situations the unpaid seller can sue the buyer for price. So this is suit for price, for non-payment of price. Number 2 is suit for damages. Let's say the seller has delivered the goods to the buyer, but the buyer is not accepting the delivery from the seller. Then in this particular situation, the seller can sue the buyer for damages for the purpose of non-acceptance of delivery. So in a nutshell, now I will tell you what is unpaid seller's right. So right of unpaid seller can be categorized against goods and against the buyer. Against the goods, there are 3 rights. First is right to lien, second right to stoppage in transit, and third right to resale. Then now right of unpaid seller against the buyer, there are 2 rights. Number 1, to sue for price, okay, which is given under section 55, and second, to sue for damages for non-acceptance of delivery, which is given under section 56 of Sale of Goods Act. So that's it from my side. Thank you so much.